As Alabama State University is taking precautionary measures to safeguard the welfare of our students, faculty, staff, and community by following national guidelines to help limit the spread of coronavirus, COVID-19, the National Center for the Study of Civil Rights and African American Culture brings this program to you virtually in keeping with its mission. Today's program was pre-recorded via Zoom, a video communications platform. The Center looks forward to bringing more lectures and other engaging content to you virtually in the coming months. To stay abreast of our activities, follow us on Facebook at Civil Rights Center and check out our website, lib.alasu.edu/NATCNTR. Stay safe and enjoy today's program.
Hello, my name is Dr. Howard Robinson. I'm the archivist at Alabama State University. Welcome to Voting Rights Revisited, the urgency of now, the 1965 Voting Rights Act, and the 21st century challenges to American democracy. We have with us Dr. D. Lionel Finley, a retired political scientist and adjunct professor at Alabama State University, to provide our invocation.
This time, let us pray, O God. We come now on this day as we celebrate our liberties as a nation, and yet we come with concerns knowing that there are those who would seek to undermine our democracy, that would make it more difficult for many of our citizens to participate. But Lord, we know that you are still in charge. And as we come this day, we come with a sense of optimism that you are going to protect your people. We pray now for our nation, pray for our leaders, pray for all of those who would give of themselves, that each of us would be able to participate in our democracy, to enjoy the fruits of liberty, and yes, to pursue our dream as citizens of this great nation. God, we pray especially for those who continue to labor, as we recognize those who have already sacrificed so much and are no longer among us. We thank you for their legacy and their hard work. And now, Lord, as we come to celebrate this 55th anniversary of the passing of the Voting Rights Act of 1965, may each of us come with a renewed determination that we would labor to see that our nation will live up to the dreams, to the promises, to the guarantees of liberties as outlined in our Constitution. We pray now a special blessing again for those who have labored to put this program together, and we pray that what we do here today would in some way inspire each of us to go out and labor even more to ensure that our liberties are protected. And whatever we would claim in the way of victory, God, we would acknowledge that you made it possible. And the people of God said, amen.
Amen. We're going to have greetings from the 15th president of Alabama State University, Dr. Quentin T. Ross.
Greetings. On behalf of the Board of Trustees, faculty, staff, student body, and alumni of the Alabama State University, I would like to welcome you to a voting rights forum commemorating the 55th anniversary of the passage of the 1965 Voting Rights Act, sponsored by the National Center for the Study of Civil Rights and African American Culture at Alabama State University. In honor of the late Congressman John Lewis, this virtual program will discuss the current state of affairs, which threaten to diminish the political gains made by African Americans as a result of the 1965 landmark legislation. Please enjoy our program.
We also have greetings from Dr. Joy Kennard of the National Park Service.
Good afternoon. My name is Joy Kennard, and I'm the superintendent of the Selma to Montgomery National Historic Trail, one of the 400 units of the National Park System. As we celebrate the 55th anniversary of the signing of the Voting Rights Act this year, we must remember all the people who fought for this right. Today, we remember the legacy of those efforts through the Selma to Montgomery National Historic Trail and through special partnerships with Alabama State University. We are pleased to collaborate with Alabama State University during such a time as this. Thank you.
The National Center for the Study of Civil Rights and African American Culture at Alabama State University, in cooperation with the National Park Service and the Montgomery Interpretive Center for the Selma to Montgomery National Historic Trail, observes the 55th anniversary of the 1965 Voting Rights Act. Today's program also honors the late Congressman John Robert Lewis. This virtual conversation is one of several voting rights programs the National Center is planning for the year. Today's program brings together several individuals to discuss the background and salient features of the Voting Rights Act, to examine efforts to undermine the landmark legislation, and to look at proposed legislative remedies meant to fully restore the legislation so central to a representative republic. A coalition of civil rights organizations, the United States Congress, and the President of the United States represents the three main protagonists in the successful passage of the 1965 Voting Rights Act. The Southern Christian Leadership Conference, or the SCLC, was foremost in that civil rights coalition. This organization was created in January of 1957, and almost from its inception, members of the SCLC began to work on extending voting rights, particularly throughout the Deep South. The SCLC was met with stiff opposition under the moniker of massive resistance, as whites across the South employed a whole host of tactics to stop desegregation and to resist any attempts to extend full citizenship rights to African Americans. The confrontation became even more volatile when African Americans attempted to register and or to vote. 1957 saw the SCLC affiliates organize voter education clinics, where they attempted to improve the political literacy and registration rates amongst would-be Black voters. In 1957, Reverend Martin Luther King and the SCLC joined the NAACP in Washington, D.C. for the prayer pilgrimage for freedom. On May 17th, the anniversary of the Brown versus Board of Education case, 25,000 people amassed in the shadows of the Lincoln Memorial. There, King delivered a speech entitled, "Give Us the Ballot." In that speech, King said, all types of conniving methods are still being used to prevent Negroes from becoming registered voters. The denial of this sacred right is a tragic betrayal of the highest mandates of our democratic tradition. And so, our most urgent request to the President of the United States and every member of Congress is to give us the right to vote. Give us the ballot, King called out, and we will no longer plead to the federal government for passage of an anti-lynching law. We will, by the power of our vote, write the law on the statute books of the South and bring an end to this dastardly act of hooded perpetrators of violence. Give us the ballot, and we will fill our legislative halls with men of goodwill and send to the sacred halls congressmen who will not sign a Southern manifesto because of their devotion to the manifesto of justice. Give us the ballot, and we will transform the salient misdeeds of bloodthirsty mobs into the calculated good deeds of orderly citizens. Give us the ballot, and we will place judges on the benches of the South who will do justly and love mercy. Give us the ballot, and we will quietly and non-violently, without rancor or bitterness, implement the Supreme Court's decision of May 17, 1954. In September, President Dwight David Eisenhower signed the 1957 Civil Rights Act into law. This law sought to counter the web of obstacles used to diminish the Black vote. This included poll taxes, residency requirements, registration offices that only open one day a month, last-minute changes of polling places. In Alabama, the voter registration application was in and of itself a literacy test, requiring voters to answer a whole host of questions. Name the man who was nationally known for heading the FBI for many years. Fill in the blank. The president is forbidden to exercise his authority of a pardon in cases of fill in the blank. There are three main types of government in Alabama: city government. Name one. In response to years of complaints from a number of organizations, petitions, countless demonstrations, and litigation, all centered around the right to vote, President Eisenhower proposed legislation to provide federal protection for African-American voting rights. The 1957 Act established the United States Commission on Civil Rights and the Civil Rights Division within the United States Department of Justice. However, then Senate Majority Leader Lyndon Baines Johnson allowed Southern legislators to significantly weaken the new law so that when it actually did pass, the emasculated law did little to extend voting rights to African Americans. Also in 1957, a group of 80 liberal congressmen led by Eugene McCarthy of Minnesota issued the Liberal Manifesto. In this document, legislators called for the government, the federal government, to do more to ensure the civil rights of its citizens, to ensure access to health care, to ensure access to education, to ensure affordable housing, and to ensure voting rights for African Americans. By 1959, these liberal officials formally created a caucus called the Democratic Study Group. And by 1963, this liberal group of congressmen boasted 175 members, and they could count on some Republicans who tended to vote with liberals, particularly on civil rights legislation. Just as liberal congressmen created the Democratic Study Group, it became apparent that the 1957 Civil Rights Act was proving to be ineffective. In 1960, chances for a new civil rights bill were improved because Senate Majority Leader Lyndon Johnson was preparing for his run for the White House. So as Southern Democrats, traditionally hostile to civil rights legislation, Johnson and his colleagues thought another civil rights law would improve Johnson's chances at the presidency. New civil rights legislation was signed into law in 1960. However, it too was watered down to the point that it did little to affect any additional changes or any improvement over the 1957 law. The SCLC would not be satisfied until they had a strong voting rights law. The pressure to put forth an effective law grew out of protest. In 1963, with the bombing of the 16th Street Baptist Church in Birmingham, Alabama, and the death of the 4 girls inside that church, the SCLC's James Bevel and his wife, Diane Nash, proposed the Alabama Project to force the state of Alabama to extend voting rights to Black parents, giving them leverage to elect representatives who would not allow terrorists to bomb their children with impunity. In January of 1965, the SCLC joined the Student Nonviolent Coordinating Committee, also known as SNCC. SNCC had been in Selma since 1963. So, together, the two organizations collaborated on a voting rights campaign. Events in Selma and throughout the Alabama Black Belt forced the Johnson administration to shift its legislative priorities. After the epic battle over the 1964 Civil Rights Act, Johnson felt he had satisfied the demands of the civil rights movement, at least for the time being. President Johnson wanted to focus his political capital on passing Great Society legislation. However, in a January 15th phone call, President Johnson told Reverend King that he needed to generate public support if he wanted new voting rights legislation, and that he needed to publicize the worst examples of voter registration injustices in Mississippi and Alabama, and to have those injustices aired on television over and over and over again. The voting rights campaign in the Alabama Black Belt brought to light a litany of abuses. Thousands of protesting students and adults were arrested, hundreds were beaten. Children were incarcerated and placed in prison camps and stockyards. Teachers marched in Selma on January 22nd. A stampede of children took place in Selma again on February 10th. Jimmy Lee Jackson of Marion died on February 26th after being shot by a state trooper. Weeks of daily protest raged in Montgomery, Alabama. On Bloody Sunday, hundreds were savagely beaten at the Edmund Pettus Bridge. Then deadly protests raged in front of the White House. Dozens of sympathy protests sprouted out in dozens of American cities. And on March 9th, yet another march was attempted from Selma to Montgomery. And then 2 days later, on March 11th, Reverend James Reeb was beaten to death in Selma, Alabama. A Gallup poll issued just after Bloody Sunday found 76% of Americans said they now supported new voting rights legislation. More than 43 members of the United States House and 7 United States senators demanded the immediate introduction of voting rights legislation. President Johnson reached out to Reverend King and sought his input in creating effective legislation. And on August 6, 1965, Johnson signed the Voting Rights Act into law. After the 1963 assassination of John F. Kennedy, Lyndon Johnson, who assumed the presidency, used all of his political capital, and he invoked the death of John F. Kennedy to push through the 1964 Civil Rights Act. With this legislation, Johnson believed he had done enough for civil rights and turned his attention to implementing the Great Society. But the SCLC demanded a federal voting rights law and launched a campaign in the Alabama Black Belt that convinced the nation, that convinced Congress, and that indeed convinced the president that the time for a strong voting rights law had arrived. Dr. Finley, as a professor of political science and a political scientist, we'd like you to talk a little bit about the Voting Rights Act of 1965. I provided some background, looked at the involvement of Congress, the president, a consortium of civil rights organizations, but we want you to touch on and to sort of explain the elements of the Voting Rights Act, and then how it was applied and whether or not it was successful.
Absolutely. Well, obviously, Dr. Robinson, you know, this is my 46th year of starting to teach government and political science. And as I look at the voting rights today, the first answer to your question is yes, voting rights has been a success. The problem is that it is under attack today because we have people in power that have labored to undermine the principles of each person having the right to vote. As we look at the history of the Voting Rights Act that we will celebrate in one day, the 55th anniversary as it was signed into law, August 6, 1965, by President Lyndon Johnson. The act aimed to discourage discriminatory practices that had gone on in many parts of our country, particularly the Deep South. And what the legislation was intended to do was wherever you found discriminatory practices, those were to be voided. For an example, many of the southern states still use the literacy test as a way or a prerequisite for voting. The 65 Voting Rights Act voided that. It also voided attempts by states who were still trying to collect the poll tax in spite of the passage of the amendment against, trying to collect a poll tax. And so wherever you found discriminatory practices that would attempt to undermine the right to vote, the 65 Voting Rights Act was the remedy to that. Now, what the act did, it really pulled together previous efforts, particularly from the 1957 and 1960 Civil Rights Act, as well as some of the 64 Civil Rights Act. The 57 Civil Rights Act, for an example, had said that if an individual could prove a pattern of discrimination, then of course the U.S. Attorney General would seek an injunction against that illegal action. Well, that was impractical because it placed too much of a burden on the individual. The 1960 Civil Rights Act was a little bit of an improvement because it did establish that if a pattern of discrimination existed, then federal registrars would be sent in. Now, fast forward to the 65 Voting Rights Act, we have a comprehensive piece of legislation that was intended to deal with the discriminatory practices that many of the states had put in place as obstacles to voting, and that's where we are today. Now, what were some of those practices? Well, many of the southern states there would deliberately draw their district lines in such a way that would deny Blacks the right to vote. For an example, the at-large systems in many of our cities. In fact, right here in Alabama, for an example, where you had the at-large commission systems there, those systems were designed in many ways to keep Blacks from having representation. As a matter of fact, when we looked at the report coming out of the civil disorders of the 1960s and 70s, there was a National Advisory Committee on Civil Disorder that says where there was a lack of participation and representation, you created a sense of frustration that could potentially lead to conflicts and violence. And so the aim was to hopefully have some representation as a way of minimizing conflict. Now, the Voting Rights Act helped to make that possible by dealing with structures that many local governments and states had put in place to keep individuals from voting. And I have lost your voice there, Dr. Robinson.
I'm sorry. You talk about the at-large system, and it reminds me not only that these devices were used to dilute Black voting and Black electoral influence, so that in places where Black people could be dispersed into different districts, so that they had no ability to vote for and elect a person of their choosing in any one district, though the at-large system was used. But there are other devices. One of the things that I think is most interesting about the Voting Rights Act is that it looked at this long history of a whole host of tactics and devices used to undermine and deter Black voting. And so can you talk just a little bit more about how the Voting Rights Act this component where there was a formula used to identify covered states or covered parts of states, and that a set of criteria or more stringent rules were imposed on those locations. Could you talk a little bit about that?
Absolutely. Now, what you have to realize is that the 65 Voting Rights Act was a work in progress, because at first it dealt with the Deep South. But if you look at 1970, 1975, 1982, there were provisions added to deal with new problems. And let me give you an example. The one that we're most familiar with in 1970, when it was renewed, at first it was voted to be renewed every 5 years, then 7 years, and then 25 years. But in 1970, for an example, it attempted to make sure that 18-year-olds could have the right to vote. Well, you know what happened with that. The Supreme Court kind of muddied the water by saying that Congress had the right to determine the age requirement for federal elections, but it could not do that for state election. And the end result was chaos, because many states like Alabama elect their state officers on the same day they elect federal officers like U.S. House and U.S. Senate. And so the Supreme Court decision really led to the 26th Amendment, which makes the 18-year-old having the right to vote in all elections. Now, another provision in 1975 that former Congressman, the late Congressman Barbara Jordan from Texas, noticed that there were language problems. Other groups were being excluded also. And so you had provisions there that were put in to deal with that deficiency. Now, the main formula in place, however, is this, is that wherever you could look at a state or a locale and you see that less than 50% of the eligible voters had been precluded from voting because of some restricted or discriminatory practices, that triggered application of the Voting Rights Act. I think that is very important, that the Voting Rights Act was not haphazardly or randomly applied. There was a formula in place to make sure that you would go after a real problem. And the real problem was that you could look at the numbers and you could see where people had been precluded from voting. And in many cases, it was well under 50%. And not only that, but it had been over a long period of time. And so there was nothing arbitrary about it, as many of my states' rights friends would like to say. The formula was pretty clear, that if you could look at an established pattern here and then see the numbers there where people were deliberately prevented from registering to vote, then you had a problem, and therefore the Voting Rights Act was the remedy.
You know, and this, I think, brings to mind the the problem that the Voting Rights Act is going to experience in the Shelby case, because it is the court's, I think, position that by looking at and identifying those covered states in 1965 was very different than identifying what states should be covered, in the new millennium. And so I'd like you to speak to that phenomenon and how the Shelby case, what was the Shelby case? And
well, first, yes, in fact, I'm looking at it right here. The Supreme Court was a little overly optimistic in the case, because what that 5-4 decision said was that the formula being used was no longer relevant because states were no longer doing that anymore. Well, there were folks who were really extremely disappointed with that, because what states, many of those locales had been doing for years in the past, they were continuing to do. But the Supreme Court said that, well, the formula that you had in place, particularly in Section 4, where the formula was laid out, was really obsolete. Now, I might add, I was one of those who was looking at that decision in 2013 prior to the ruling, and I was one of those things that, I just hope that they don't end Section 5. Everybody thought they would end Section 5 dealing with the pre-clearance and the intent, and they were saying, if they wipe that out, we would be in trouble. And I was one of those things saying, well, now if they wipe out Section 4 and the formula, and we still have Section 5, we could probably make it, because it would be, you could bring the suit, but the lawyers would have to work just a little bit harder with the court. Well, lo and behold, many of us got Section 4 overturned, and Section 5 remained. But unfortunately, what we didn't anticipate, and I did a little paper entitled Voting Rights Surviving in a Judicial Hostile Atmosphere, because I really thought that even without Section 4 in place, we could still use Section 5 that Shelby County had in suing Attorney General Holden had successfully gotten the court to overturn. What many of us did not anticipate, however, that you would have these judicially hostile judges, and when I say judicially hostile, I'm talking about hostile to voting rights, that many of these judges have a decided anti-voting rights attitude, and they are not willing to listen to any kind of argument where you're showing a desperate impact on minorities there. Now, the one thing that the court did reason in overturning Section 4, it said that in saying that the formula was obsolete because you are applying something to Alabama and other southern states that you're not applying across the nation, and that it is unconstitutional on that basis, but secondly, it is no longer relevant. Well, that's the part that those of us who are advocates for voting rights have a problem with, because we contend that since the voiding of Section 4 by the Supreme Court, you see many of the locations in the South and outside of the South going back to putting in place obstacles to make it harder for people to vote. For an example, many states that no longer have to pre-clear now have wiped out early voting. They have wiped out same-day registration. They have wiped out online voting, and they have shortened the number of days that a person would have to vote early. All of those have been tactics to reduce participation and, of course, undermine the right to vote. So for those who would say that you didn't need these remedies in place because they were obsolete, I think the evidence post Shelby versus Holden demonstrate that those who had said these states would not be fair partners in voting rights have been proven right, because we see the continuing restrictions now. And I might add something.
Let me interject here. And I think that it's my understanding that one of the reasons or rationales that the court used was that this problem with the pre-clearance in those covered states could be addressed by Congress. And so Congress needed to come back and then recertify or re-identify states who had a pattern of practice of discrimination against certain segments of society, and then cover those states again so that they would be subject to pre-clearance. That is not that seems like a reasonable expectation on the part of the court.
That Dr. Robinson, you're exactly right, and that is exactly what Chief Justice Roberts pointed out. He fully expected Congress to come up with a new formula that would not be discriminatory and would deal with the restrictions where you found them. Now, that I think the Chief Justice was a little bit overly optimistic. Yes, you're right in saying that the Supreme Court, the language is reasonable. The expectation is reasonable. The outcome, however, in dealing with a hyper-partisan Congress makes what is reasonable impossible, because you have individuals now who really don't believe that they can win a fair election. And I say that with a number of proofs in place. Many of the Republicans have come to believe that they cannot win an election where you have a significant turnout. And in order to reduce that, they want to put as many obstacles in place to prevent a high voter turnout, because a high voter turnout would tend to undermine their ability to gain a hold on to power. But Justice Roberts was correct in his assumption. Unfortunately, the events that have developed afterwards have really made his reasonable argument and his reasonable expectation impractical, because a hyper-partisan environment is not going to come up with a formula that would deal with the restrictions.
And well, in a sense, because now Congresswoman Terry Sewell of the 7th Congressional District here in Alabama, which is, I think, appropriate. She represents Selma and parts of Montgomery. She did introduce legislation that would address this issue. Could you talk to me about that legislation and its even its more recent iteration in terms of the naming of that legislation after Congressman John Lewis?
Well, actually, it was introduced as House Resolution 4, and it's called the Voting Rights Enhancement Act of 2019. It passed the House in December 6th of 2019, and it was submitted to the Senate and received by the Senate Judiciary Committee on December 9, 2019. but it has lingered there because Majority Leader Mitch McConnell has not allowed any action on it. Essentially, what her act would do was where the Supreme Court found statutory deficiency. In other words, where the court said you need to come up with a formula to deal with discriminatory actions, Congresswoman Sewell's legislation would put back in place a formula. And one of the things that I found interesting in her legislation was that if you looked at a jurisdiction and you would go back for 25 years and you found that that particular jurisdiction had a pattern of doing things that would disproportionately impact certain voters adversely, then of course you would have voting rights remedies to apply. And so it's a pretty good piece of legislation. It deals with, some of the more detailed things. Now, one of the things that I would have asked the Congresswoman about had she been here today, the legislation assumes, of course, that you don't have a final judgment against, certain of these provisions, because obviously if you have a final judgment like a Supreme Court decision against some of these provisions, that would do pretty much what the Supreme Court did in 2013 to Section 4. But again, I want to see how far House Bill 4, which is called the Voting Rights and Advancement Act of 2019, I want to see how far will it go. I want to see if many of our Republican friends will support it, because as you look through the legislation, it is reasonable in calling out restrictive tactics. And it has an objective standard. It's not arbitrary. Again, for the sake of repeating, you look at an area and you give them an opportunity. We go back 25 years. Have you had a pattern of the previous 25 years of doing things that purposely restricted the right of certain people to vote? If the answer is yes, then this triggers some kind of intervention, which I think is a reasonable piece of legislation.
It seems like this may be answered more definitively, or there's a potential for it to be answered more definitively after the next election. Is that your feel?
I would think that right now, an election is the only way that you're going to bring some resolution to this, because in the current environment, you have the kind of stalemate where some people just don't have an interest in expanding the voting franchise that would allow more people to participate. And that is unfortunate and sad in our democracy, because many people around the world are watching us. Other nations often call on us to monitor elections because they believe that we support fair and open elections. And yet when you see these kinds of voting restrictions taking place, they cause other nations around the world to wonder if we really do believe in a fair and open democracy whereby each person who is eligible will have a chance to participate in our democracy. And I think the only way that we are really going to get some resolution to this is to look at an electoral outcome that is different from what we have now.
I think you have brought to our program a degree of expertise and an explanation that I hope allows people to understand more clearly what the issues that face the Voting Rights Act, what the Voting Rights Act consisted of, what challenges it faced, and then what are the prospects for its future. If you have any words you'd like to say in summing up your comments, you could say that now.
Well, I'm going to sum it up the same way I did when I looked at the decision in 2013. Even though it may be judicially harder to win some of the cases, I do want you to know that victories are still being won in many countries. And also I said countries, but many states. Victories are still being won in many states. Let me give you a good example. Many of the Republican Secretary of States have made it clear, for an example, that they have not seen the fraud in voting by mail that the president claims to exist. You know, that would not allow any fraud. Secondly, MIT has done a statistical study that shows, my goodness, they had 0.0000 some percent of 250 million ballots that have been counted, and where they just found fraud there. Well, to make the long story short, there is no fraud in mail-in voting. And even the president himself realizes that when he made a distinction between Florida, when it was pointed out to him that Florida uses mail-in voting. And so his argument is that, well, DeSantis and other Republican governors, they've gotten it right, but where Democrats controlling mail-in voting would be fraudulent. The fact of the matter is mail-in voting worked. And so I think in COVID-19, we are going to see some innovative ways to increase participation in our electoral system over the objection of many people. Secondly, I think we need to look at this, and this is the thing what we need to take serious, that individuals will still need to use a lot of initiative themselves, because if you don't go out and vote, how do you know you can't vote? You can't say that I have been prevented from voting if I don't try to vote. And so I would encourage people that even if you perceive that there are obstacles out there, at least go and try to vote, because there are things still in place. Even in Alabama, you still have absentee voting. So if you need an absentee ballot, apply for an absentee ballot. If you need to vote early, go down to the clerk's office there and vote early. Take advantage of opportunities to participate where they exist.
Could you just one last thing, if you could just touch on the impact you think the appointment of a whole series of federal judges under the Trump administration might have on voting rights and the voting rights?
Well, thank you. As a matter of fact, I had kind of skirted around that when I said that since 2013, we see an increasingly judicial hostile environment that makes more difficult what I thought would have been easy, would have been possible to do, even if somewhat difficult, that you left Section 5 in place. But as I said, I had not anticipated the host of federal judges who have been appointed since 2013, and especially during the Trump administration, who come with hostility towards Voting Rights Act. I think those individuals have made it more difficult, not impossible, but have made it more difficult for many of the restrictions to be removed. As a matter of fact, they have allowed some restrictions to be in place. For an example, in Wisconsin, the state there wanted to delay its primary because of the COVID, and then wanted to make it possible for more mail-in. Well, the court made it harder for that to happen. People still turned out to vote, but they had to stand in the rain to do it. These judges have also allowed states to shorten the number of days that they allow people to vote prior to the election. If you notice, some states have days before the election in which they allow folks to vote, which we call early voting. Well, those states have been permitted to shorten that time frame and thereby lessening the opportunity for participation. And so we see that particular impact there.
I want to say at this point, want to thank you for agreeing to participate in this conversation, and just to say to you that we are the National Center for the Study of Civil Rights and African American Culture at Alabama State has been working in partnership with the National Park Service and the Montgomery Interpretive Center for the Selma to Montgomery National Historic Trail that's on the campus of Alabama State. They have proven to be partners. We are planning a series of programs related to voting rights, and we hope that you would be a regular participant in these programs.
I would be so honored to participate wherever you feel that I can make a contribution.
Thank you so much. We're going to turn now to Dr. Janice Franklin, and she's going to provide some closing remarks.
I'm Dr. Janice Franklin, Project Director for the National Center for the Study of Civil Rights and African American Culture at Alabama State University. On behalf of our National Center, I would like to thank all of you for joining us at this historic event, celebrating the 55th anniversary of the signing of the 1965 Voting Rights Bill. We are happy to host this event in remembrance of the outstanding life and legacy of our beloved Congressman John Lewis, whose work and sacrifices for human rights will be forever honored and remembered. May I take this opportunity to thank our esteemed guest presenters, including Dr. Quentin Ross, President of Alabama State University, and National Park Service Superintendent, Dr. Joy Kennard, for their participation on our program, along with our faculty contributors, political scientist, Dr. D. Lionel Finley, and historian, Dr. Howard Robinson. We are sincerely grateful for our presenters' long-term commitment to advancing the cause and study of social justice and the culture of African Americans. Finally, as we continue our mission in the National Center to preserve and teach the rich history of the modern civil rights movement in African American culture, I would like to also thank those who have made this program possible, including retired Professor of History, Dr. Dorothy Autry, and Cultural Heritage Manager, Ms. Destiny Williams. Special thanks are extended to our Provost, Dr. Carl Pettis, and the Office of Academic Affairs, members of the National Center staff, and university departments who have assisted in the development of this historic program. In conclusion, may I say that now more than ever, we must honor, celebrate, and continue our struggle to reinstate the full intent of the Voting Rights Bill, ensuring that all Americans have the guaranteed right to vote. This right is indeed the cornerstone of our American democracy. Thank you all in our audience for your attendance and support of our center. We hope that you will look forward to future programs presented by the National Center for the Study of Civil Rights and African American culture at Alabama State University, the university at the heart of the modern civil rights movement. Again, thank you.